All right, good morning. I want to welcome you on this beautiful Monday morning to Nashville to the October 2018 edition of the Real Estate Appraiser Commission. And I suppose at this time I'll just turn it over to you, Roxanne.
Thank you. Yes. Chairman Thomas, thank you very much. Today is Monday, October 15th, and notice of this hearing and today's meeting as well as tomorrow's was posted on the board's website on October the 11th. So to start, I'd just like to do roll call to make sure that we have quorum. Ms. Rosie Johnson is not here today. Mr. Randall Thomas?
Here.
Mr. Mark Johnston? Not here yet. Dr. Warren McCara?
Here.
Mr. Rex Garrison?
Here.
Mr. Jim Atwood?
Here.
Mr. Jason Bennett?
Here.
Mr. Brett Mansfield?
Here.
And Ms. Michelle Alexander? Here. We have quorum, and I would like to take this opportunity to welcome our two newest members on the commission. They went through orientation today, and so you have Mr. Brett Mansfield and Ms. Michelle Alexander. We are thrilled to have a full commission now. With that, we will start on our agenda, and we have as the first thing a formal hearing, and I will turn it over to the litigating attorney, Mr. Dennis Gregory, to welcome the judge and go through the procedure.
Dennis Gregory for the agency. Members, we have a formal hearing that's going to be presented to you today. The respondent, Ms. Mary Neal, is present with us. I have copies of the notice here and charges for all members. Your Honor, do you want me to go ahead and distribute those
I don't.
now?
I would like to wait until we convene the hearing.
Okay.
What is the status of our respondent?
Respondent is here.
Okay. Very good. If you would like to come up to the party table.
The light is red. Okay.
Is everyone ready to proceed? Commission and parties? Okay, very good.
I'll go ahead and distribute copies of the notices. Okay.
We have convened for a hearing before the Tennessee Real Estate Appraiser Commission. That is the matter of Mary Neal, and it is docket number 12.18-153-474A. My name is Kim Summers. I am the administrative judge assigned by the Tennessee Secretary of State to preside over this hearing. As the administrative judge in this matter, I will not participate in the decision on the merits of this case. The members of the board that are present will make that decision. I will, however, make all rulings on evidence law and procedure under the authority granted to me by the Tennessee Administrative Act. As we have previously determined, we do have a quorum, and who is our presiding board member? Mr. Randall Thomas. Excellent. And we do have the respondent present with us this morning, and counsel for the department has already identified himself for the record. If you would now please pass out the notice of hearing and charges, and if the commission members would review the document, and you will need to disclose if you have any prior or outside knowledge regarding any of these matters. And if there are any such prior knowledge, it will need to be disclosed on the record. So I'll give the commission members a few moments to review. While they're reviewing that document, I'll just review the technical record, which is short from what I can tell. The notice of hearing and charges filed in July, and then a pre-hearing order issued on August 21st, and a notice of witness and exhibit list filed September 28th. Either party aware of any additional documents?
I'm not, Your Honor.
Anything that has been filed. Okay. And you do wish to proceed in this matter without the benefit of counsel? Okay. And you'll notice when I'm speaking, this light goes on, so you'll have to.
Yes.
Very good. Any prior or outside knowledge that needs to be disclosed on the record?
I'm not certain any of these cases were related to any work that Ms. Neal had done for us previously, but all three of them could have been for the firm that I own.
Do you have any reservations regarding your impartiality in this matter?
Yes.
Would there be a quorum without this commission member?
Yes, I think we're okay, Judge.
It's entirely up to you. It's up to the individuals as to whether or not they would wish to recuse themselves, and that's entirely your decision.
I think I should. Get up, move the back.
Go ahead and push your button to be on the record. Thank you.
But is it necessary that Jason leaves?
It'd be up to you.
He does not need to leave, but if he doesn't feel comfortable participating in the decision on the merits, then that is entirely up to him.
So you understand, and Jason is our AMC member. So that's where he's speaking from.
During the course of, members of the commission are reminded that during the time this hearing is being conducted, no discussion concerning this case should take place between commission members or with witnesses, attorneys, or other persons unless all parties are present. During the hearing, the commission sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires all commission discussions and deliberations to be in public before all parties. Failure to observe the Sunshine Law may result in the commission's action being reversed or remanded if appealed to Chancery Court. Commission members, you are reminded, well, we've already done that, you will have an opportunity to ask questions of witnesses during the hearing. Any questions regarding the opening charge? Okay, are there any preliminary matters that we need to address before we proceed with opening statements?
I don't think so, Your Honor. We had no stipulations. That'd be the only thing that I could think of that we might have had, but we didn't.
Okay, you may proceed with your opening statement.
All right, members, again, my name is Dennis Gregory. You've seen the notice of hearing and charges. This is pretty straightforward, at least from the standpoint. It may be more complicated to you all as we get into this, but essentially we're going to be talking about 4 separate incidences involving the respondent, Ms. Neal. All these incidences deal with really a matter of whether or not Ms. Neal performed her duties as an appraiser as she was supposed to. We're not going to be talking about any technical USPAP violations, or essentially these are all going to be surrounding or dealing with the matter of ethics, really. First, we believe that we're going to be able to prove that, number 1, she's a licensee subject to your jurisdiction. 2, that on or about August 29th, 2016, that Ms. Neal was to conduct an appraisal and return the report to the bank, and the state's position that didn't happen, or at least the report was not turned in. The second complaint deals with actually the same day, August 29th, 2016, about Ms. Neal failing to complete an appraisal. Third, on or about October 4th, 2016, or sometime before that time, the evidence may conform what the ultimate finding is. But there was another inspection that was to be done where there was an appeal by one party of the appraisal, and whether or not Ms. Neal completed her portion of that appeal. And then finally, the fourth incident was sometime about November of 2016, when an appraisal was to be performed by Ms. Neal that was not finished. Those are the allegations, and I would begin by calling our first witness.
Okay, well, we have to give the respondent an opportunity for an opening statement. Ms. Neal, you may make an opening statement. Since you're representing yourself, an opening statement is very similar to testimony. If you would prefer, you can waive an opening statement until it's your opportunity to testify.
I guess I prefer to waive it because I really don't. I'd rather wait and just put each case on on its own merit, so
Okay,
I can explain
that's
it.
fine.
And I'll be better able to follow.
And again, you certainly will have an opportunity to provide testimony. You will also have an opportunity to ask questions of the state's witnesses. You might want to make note of any questions that occur to you while they're testifying.
Thank you.
And so you may proceed.
The agency calls Roxana Gmuscio.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but?
I do.
Ms. Gmuscio, Roxana, what do you do?
I'm the executive director with the Real Estate Appraiser Commission.
And how long have you been in that position?
Approximately almost 2 years.
And were you the executive director in 2016?
I was at the end of 2016.
Specific to this case, do you have any general knowledge about the complaints lodged against Ms. Neal?
I do. I have the information regarding the 4 separate complaints.
And just not asking specifically by name, but who were the complainants in these cases, in these 4 cases?
In all of the cases, they're coming from the general public, individuals that sought after the work being done, and they each complained about service.
And so these were not other appraisers?
That is correct. They were not.
Okay. And are you also the custodian of the records for the Home Appraisers Commission?
Yes, I am.
Are you aware whether or not that any of these complaints lodged against Ms. Neal received responses from Ms. Neal? Not what she has brought with her today, but prior to today.
The complaints were opened between September 20th of 2016 as far as an actual receiving of the complaint all the way to December 16th of 2016, and no, we had no response.
Finally, are you aware if at the time, 2016, at the time the complaints came in, did Ms. Neal hold an appraiser's license with the state of Tennessee?
Yes, she did.
Okay. And does she hold one today, to your knowledge?
She does. It's an active license.
Okay. All right, I think those are all my questions.
Do you have any questions for this witness?
No, I don't, not at this point.
Okay, well, this is your opportunity to ask her.
I don't have any questions.
Okay, your next witness.
State calls Mary Neal. Now, how you want to, whether she stays there or...
That's fine. You may raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay.
At the podium. You are Mary Neal.
Yes, I am.
Okay. And on or about, well, let's just say for the year in 2016, were you a licensed appraiser?
Yes.
And I don't think you need to push the button. I think
Oh,
if
just
you
on the
just
straight. I'm
speak,
sorry.
yeah. Well, it's the, you're going to extra effort.
Okay.
All right. You were contacted, and are you okay if they're somewhat leading? I mean, if she testifies, I'm going to lead her as well. I mean, would the court give a little bit of latitude, or would you? Some, okay. Were you contacted by folks down well, were you contacted on or about August 29th, 2016 to perform an appraisal?
Yes, I will. I'm sure. Can you give me the name so I can pull my file? Who the complainant was, please?
The complainant Kimberly Rednauer. Now, this would have been property in Reedyville, Tennessee.
Yes.
Okay. And do you recall when you were supposed to arrive at Ms. Rednauer's property?
That was one that I just, when I scheduled the appointment, I was going to be in the area, and I asked them if they need a definite time, or would just after lunch work, would somebody be home, or would the house be available? And the agent that I spoke with, I didn't speak with Ms. Rednauer, but the agent that I spoke with assured me that that would be fine. They were anxious to get it inspected, and if I could do it that day, they were happy to have me come.
So did you complete or did you conduct an appraisal on August 29th, 2016?
I did.
Okay. Do you recall what happened to the appraisal report?
I sure do. Matter of fact, I have, if anybody would like to have copies of these, I have some information there. I went out and inspected the property. Ms. Rednauer's complaint was that I ran around and took 45 minutes to inspect the property. As far as time frame, I don't know how long I was there. I don't have any idea. But I do know that I have a complete drawing, all my notes, everything that's necessary. It was a manufactured home, 4.49 acres, rural area, guest house, auxiliary unit. It had attached garage. and manufactured, I think I said that. It, extremely difficult, complex assignment, so I don't know how long it took. But anyway, after I went out and did the inspection, I contacted the lender, told them it was going to take a few extra days. I didn't know how long. Contacted the agent, as I always do, and asked if they have any comps that they had used when they priced the house. And they didn't have anything. I think their comment was, pretty certain it was, it's nothing like it, nothing else like it in the area. So kind of on my own on that. I looked, searched all the areas of Rutherford County. And during this time, Mr. Redenauer came to my house twice and was very, very pushy, very wanted that done. Somebody else had already been to his house to appraise it and didn't turn the report in, and he needed this done so it would close because his family needed to move and needed more space, whatever reason. And I felt threatened by it, and I turned the report back in and did not finish it. I did not. That was a business decision made just because I felt like it was something I didn't need to be attached to.
Was the appraisal report, had it been turned in, would it have been turned in to the bank?
Absolutely.
Okay.
To the AMC, actually.
Okay.
And another, I did speak with the Redenauers, and at length, on the day of the inspection, I always answer any questions that they have, always try to be courteous, and because I know it's unique to them. It's something we do every day, but it's not something they do every day. They have questions, and they were anxious.
All right, well, let's move on. Let me ask you, were you ever scheduled to appraise a property belonging to an Angelia Nelson?
Yes.
And was that in Winchester, Tennessee?
Absolutely. Yes, Sales Avenue, Sales
Okay.
Street.
You were scheduled to perform an appraisal on or about August 29th, 2016, is that right?
Right.
And that would have been on the same date as the other complaint we just got through talking about?
Right, and that's why I had that time frame was kind of up in the air because I didn't know what time I was going to make it over there.
Was there something that special or unique about this particular appraisal?
There was a dock, pier, whatever they wanted to call it, on that property, and they didn't have any information from TVA in the file, in the report, or in their contract anywhere. And when I did the inspection, I wanted to make sure that it was either legal, not legal, whatever, because it depends on what I'm going to pull as far as comps go. Now, I'm not sure. Should I be looking at you guys or Dennis? I feel like I'm ignoring you.
They're your audience.
Okay, I feel like I'm like, I don't know which way to go. Okay, so anyway, I felt like I needed the information. To be able to do a credible report, I needed information on the dock. So I requested that of Miss Miller, and as usual, of course, I'm not working for Miss Miller. She's the seller. My client is happy with where we are in this program. I notified my client. They put the order on hold. Now, whether Miss Miller knew it was on hold or not, I'm not privy to that. I don't know. But I would think she would because she was the agent as well as the seller. So she told me they had letters from TVA that it was on TVA property and that it had to be torn down, but that the TVA was going to allow it to wait till they lowered the water level. And she said she had letters to that effect, and when I asked her for the letter, she never provided me with a letter, ever. And if they had them, I would obviously like to have had it. I did turn this report in. I spoke with the AMC, with their senior appraisers or their appraiser advisor board, to find out what should I do, because it was going on with time and I'm taking a lot of abuse from the seller because of it. I actually received a letter, or a fax actually, from Miss Miller. I'm not sure which day this came in, but pretty firmly requesting that I send the report in. She's not interested if I send it in credible. She just wants it in so they can close. And P.S., if you fail to respond within 24 hours, both the lender and myself are going to report you. At no time did this lender complain about the report, the time it was taking, or anything like that. I mean, this is pretty typical to get everybody involved is anxious, but they don't understand that this is a process. It's not cookie cutter. You can't just turn these things. When they're difficult, you've got to, and complex, you've got to take the time it takes. Inform your lender, and that's what you do. But that's pretty much on that one. That's what happened. And I did turn the report in. They did close.
And when did you turn the report in? Do you remember? I'm not asking for a specific date, but what do you think? If you did
I turned it in on the 27th The 26th of September, actually.
Okay.
And it had been on hold during that time. And I tried to pull the information. It was a Bank of America, which I do Bank of America all the time. It was a Bank of America file, and all the activity and messages were gone from the report. I've got the report as far as the status and those kind of things, and when it was ordered, when it was updated, not. But that's all I have. But it was actually turned in on the 26th day of September, and I think they closed like on the 30th. So
Were you compensated for this appraisal?
I was
Okay, by the bank or by the homeowner?
AMC.
All right, let's move on. Do you recall conducting an appraisal at the home of Jeremy Parham in Murfreesboro?
I do.
And do you remember roughly when you were assigned that appraisal?
I accepted the order on September 23rd. The inspection took place September 26th. The report was turned in on September the 30th, as per the engagement letter. Every one of those dates is in the, I was able to pull all the information on that. All the dates are justified and substantiated by my report.
And in that instance, with Mr. Parham's, in that incident, was there an appeal by the homeowner of your appraisal?
It was actually by the seller for a reconsideration of value, which the AMC sent, and I did the report, I did the reconsideration. I received that on the 4th. Well, it was sent over on the 4th. On the 7th, I told them that I would be working on it that day. On Monday, I went back and got my comp photos and sent it in on Tuesday. That was a Friday, so I didn't get it by the end of the day. But I did get the report completed. So I think it was like 11 days or 10 or 11 days from beginning to end. The report was sent in on time as requested, as per our agreement.
So in the case of an appeal, are you aware whether there's a set time to finish the portion of your appeal, or is it just by agreement? You just said it was by agreement. If it's done by agreement, even if it might be otherwise late, is that okay?
Not really understanding the question.
Well, are you aware if there's a set time in which you have to finish the portion of your portion of the appeal?
This appraisal. We're, okay.
Yeah.
Those are just like, I suppose when they say you've got 72 hours, if you can do it in 72 hours, that's wonderful. But if you can't, you just say, I'm going to look at it this day and I'm going to do it and it's going to be done. But it's nowhere in my order did it say when I accepted the order, it didn't tell me I had 72 hours for an appeal or a review or whatever. But obviously there's time sensitive. I don't know if that answers your question or not.
I think it does. And one last question on this one. Were you compensated for this appraisal?
I was. And let me add to that last statement, if I could. Everybody's is time sensitive. You've got 25 people yapping at your heels every day. And you've got, these things, once you send them in, if you get a review, or not review, a revision request, typically they're back out that same day. But when it's a reconsideration, there's a lot more involved than just correcting a date or I'm sorry, I'm not looking, a date or something along those lines. It's, you've got to start your review, your analysis. You've got more analysis to do. You've got more things to consider if you're doing due diligence.
All right, then let's talk about the final complaint. Were you scheduled to do an appraisal sometime in November 2016 for a Sean Norton?
Yes.
Okay. And when I said November 2016, do you remember the specific date?
I have all that. The date it was assigned to me was December the 2nd. I inspected the property on December the 9th and delivered the report on December the 20th. The reason for the time lapse in that one, I think it was due maybe on the 15th, 16th. I can look that up. It's a custom-built house, new construction, 3,400 square feet, 4 bedrooms, 3.5 baths, 2-car garage, 1.51 acre, rural Bedford County. I'm not sure if you guys are familiar with Beech Grove, but it is, portion of it's in Coffee County, portion of it's in Bedford County, and it bumps up to the Rutherford County line. I had 3 counties that I needed to look in for something that was comparable to that, rather than just doing pulling from a subdivision that had spec-built houses. I was trying to find what I needed, and the lender was aware of that. And I turned it in, so actually it was 11 days from the date it was inspected to the date it was actually turned in.
So in Mr. Norton's case, this the home Beech Grove, was the appraisal finished,
Absolutely.
and was it submitted?
Yes,
And you believe it was submitted, you said 11 days.
I know it was.
Okay. And with this particular matter, were you also compensated?
Yes, I was.
Okay. Now, Ms. Neal, all of these complaints were generated within, I believe the first one we talked about was in August, or rather,
Oh, November, or
August,
October.
October and November. Any reason these were all within a few months of each other?
Lucky like that, but not to be flippant about it, but that was a very busy time in appraising, and they were all unhappy because of the time frame. Everybody was. It was taking longer to do reports, not just in ETAs, but just simply because of the volume. You just had to put your due dates out and explain to the customer, hey, I can't do it. And when you got a complex report, it took a few extra days. And the lenders typically want them back within 7 days. 48 hours after inspection, if you get to inspect it, say you're going to be in the neighborhood and you inspect it the next day, then your due date changes from 10 days out to 48 hours from the date of that inspection, and you don't always have time to do it. It's just that way. And so you tell the lenders, I was in the neighborhood, I inspected it, but still everybody expects it back in that 48-hour window.
And how long have you been a licensed general appraiser?
92,
And have you had any breaks in that amount from then till now?
never.
How many inspections do you believe, or appraisals rather, have you conducted, do you think?
Gee whiz, I don't know. I have absolutely no idea. None.
That's fine.
A lot.
Those are all the questions I have.
Questions from the commission members?
I know you'll have a question.
When you received the complaint notice from the commission, why didn't you respond?
I actually sent letters to Miss Sarah Matthews. I don't know where she was in the loop. I have my complaint, but I don't know what else I should have done. And when I received that first consent order back, I assumed that was because of what I had sent in, and that you guys had just decided to do the fine and the classroom hours, which I never have a problem with classroom hours. That's a learning experience. But I did kind of have a problem with that fine, so I wanted to at least present my case. And so I just figured that that consent order was your decision. Since they were so close, I actually sent them all in the same envelope with the different things on there.
Roxanne, we don't have any copies of anything that came back to us?
No. And the consent order obviously would have given a response time for information to be sent, not to Sarah Matthews.
Maybe I'm just not real savvy on that, but I thought if I signed that consent order, I was just agreeing to everything, and that was just the way it was going to be.
Anyone else have any questions?
Was this an unusually busy time, or was it just typical of your?
It was a very
schedule?
busy time. 2016
Okay.
was a very busy time.
Unusually busy.
Unusually busy, and it was taking a little longer on reports just to get them inspected. Inspection dates could be 2 weeks out. So for a report to take 4 to 6 weeks in that time frame, I don't think would have been even an ordinary cookie cutter. Now, some of the other appraisers might know more or disagree, but that wasn't real unusual. And now, not during this time, but there was a time in 2016 and some of 2017 that while I was still active and worked, I had to be with my mom at the nursing home for about 3 months, but I still did what I could. You know, she was not in the same place I was city-wise. I didn't have any help, and I did what I could. But did I lose business during that time? I sure did, but I still couldn't change that. I wouldn't change that.
That was going to be my next question, if
Yeah.
there was anything going on in
There
your
was,
personal
but that
life.
was just that, and I don't really think that any of these were affected by that, to be honest with you, time-wise, because that was earlier in 2016 and more, like, really towards the very end and 2017. Lots of but in 2017, it was very sporadic and just a couple, 3 days at a time, because I got her closer to where I was.
Jim?
Yes, Ms. Neal, where is your office located?
Chapel Hill, Tennessee.
And I notice these reports are in multiple counties. How many counties do you service?
I'm in Chapel Hill, and whatever fans out about around, and Coffee and Moore County, I've done for forever, since I started, because I'm very familiar with it. I have people that live there family-wise, so I do those.
So you do Rutherford, Williamson?
Rutherford, Williamson, Murray, Bedford, Marshall, and there was a time when I did Giles and Lincoln, but that time is past. I don't do them anymore. The counties are so vast and so spread out, and the comps are so difficult that ETA is a real problem in those counties, for me, because I'm too far away from them.
Were any of these appraisals rural properties?
Except for Mr. Parham's. Mr. Parham's was in Murfreesboro, and the Sales property, which was the Miller, it was in Winchester, in the city on the lake, because the lake kind of runs all around through there. But it was in the city on the lake, so it was not. But the Norton, which was the Tom Walker Road, it was in a very rural area. And 24 runs within probably 2 miles. You've got Interstate 24, and then it was in Bedford County, and Coffee County is within 2 miles, and then Rutherford County and Christiana, I'm sure you know where that is, it's within another 5 miles. So every one of those areas I needed to check, not just for homes similar to that, but if I could find something that was a custom built, more along the line of a custom built, higher value, or higher quality value, higher quality. That's what I was looking for.
One more question. When you're not burdened with family issues, approximately how many appraisals do you complete a week?
You know, in the old days, I could do a whole lot more, but I would say now probably with inspecting, from the time they're inspected and actually turning out reports, I'll inspect 3 or 4, and it'll take 2 days to get them out. So I would say probably 4 to 6. And now that is if they're nice little cookie cutters in a subdivision. If they're complex properties, not so much, because I worked on a lake house the other day all day long. And that's not including the inspecting, which I was there half day. So that's a 2-day report. It just depends on what it is. And I don't get many cookie cutters.
Yes, sir. Mr. Mansfield.
All right, and the second complaint here with the property in Winchester, it states that you would not sign off on the appraisal. So did you provide an as-is appraisal, or was this subject to some?
It's an as-is appraisal. That was just, let me look at the report one more time, but so I can make sure I understand your question. But absolutely, I did sign off on it. What our holdup was the real estate agent, who was the seller as well, told me she had letters from TVA, but would never provide them for me. And I never told her I wouldn't sign off. There is no signing off unless it is a subject to. So I wouldn't turn the report in until I had something that told me what the status of that deck was. You know, who owns it, which land is it on, because it's important. If that buyer thinks he's buying something that has a permit for a pier, I sign off saying I've done due diligence and I've seen that permit, then I may get to build a deck. You know, or not a deck, but a dock or something along those lines. So it was just a matter, and the bank was, or AMC was totally aware of that, and Bank of America was brought in on that juncture, and they put the appraisal on hold. And I think Wendy Camacho is the one I spoke with. I'm not sure it was Wendy. It might have been Elaine, but we batted it back and forth. And
What else?
that answer your question?
I have a couple questions for you. On the fourth complaint, who ordered the complaint? Who was your client? All I want to know is a homeowner or a lender.
Tell me who the fourth one is. Is it Norton?
Yes, ma'am.
Who ordered it?
Yes, ma'am.
The AMC ordered it.
That came from the AMC?
Yes, sir.
Okay, and you say you were compensated for it.
I was.
I'm pretty sure AMCs don't pay for appraisals unless they're finished. So
And
where it said-
approved.
So this says it was never finished, but you say you were compensated, so obviously it was finished.
It was, and I think Norton's, I have a copy of my, of the order that shows the date it was turned in, but absolutely. The only report that's in this files that I did not finish was the Murray Kittrell Road in Reedyville, and it's just had a lot of stuff going on with that. A lot of
Now, on
stuff.
the Parham one, number 3, your reconsideration of value, did you change the value?
I did. I
Okay.
did. They had two
That's all I
comps.
wanna know. And who was in number 3, who's the intended user?
I mean, who number 3 is, please?
Parham.
Parham, the intended user was, the client was, do you want me to take?
I just want to know if it was a lender? It was a lender,
The lender,
okay.
yes, the intended user was a lender on all these reports.
On all of them?
Mm-hmm.
Okay.
Can I make it, and the AMC, all these were ordered through AMCs, but of course I dealt with them, and then the lender was brought in at that point.
Can I ask for a point of clarification? Did any client lender file a complaint?
We have this witness. We can
Oh.
we can recall. I mean, you can ask her anything that you want to. She's the only person
Okay.
we have.
I'll wait.
Anyone else have any questions?
All right. Thank you. Further witnesses?
No, Your Honor.
Is there any additional testimony that you would like to provide?
Well, I would like to respond to Mr. Atwood's question if I can, or can I?
Well,
just
you
make a
can
statement?
provide
I can say
whatever
anything.
testimony you
Okay.
would like to provide.
I've been in business since 1992, and I've never had a client to complain. Have I had them to send back for revisions? Absolutely. Have I been late on reports? I have, but not to the point of causing a deal to fall apart. I consider myself to do probably above board, staying up into whatever hours it takes to do the reports, et cetera, et cetera. But there are times when that happens, but I've never had a lender to complain directly. I've never had any letters of reprimand from a lender. That's just, have I been removed from AMC? I think there was 2 during the time that I was with my mother, and again, that was just something I couldn't avoid. And it may happen, some other situation may happen in the future, but well, I don't know what else to say. I consider myself to work within the ethics. I work hard. I try to do a good job, and that's pretty much it.
Were there any additional questions for the respondent? Did you have any additional evidence that you wish to put in front of the board?
Well, I've made copies of all these things, but we've basically covered them. You're welcome to have them, or you don't. We've covered everything that I made copies of the, as an example, Mr. Parham's. I have the letter, or not the letter, but the order that shows all the correspondence between the dates it was submitted, and everything in that is right where it was supposed to be with my agreement on the engagement letter. And Norton's, same way. So I suppose that's all I have.
Did you all wish to recall Ms. Camuccio? Okay.
You know my question, but I'll ask it again. The complainants, are any of the complainants, you said they were public, so I'm assuming no lender, no AMC, no bank, no client filed a complaint on any of these?
That is correct.
With the same witness, would I be correct in saying that none of the intended users filed a complaint?
You're referring to the AMCs? The banks?
Or stated in her report, when she stated who the intended user was, none of them filed the complaint. Okay, thank you.
No, Your Honor.
Okay. Would you like to make a closing statement?
Just sort of to summarize, Board members, you've got everything in front of you now in terms, and it's mainly all going to rely just on the testimony that's been elicited from the executive director and Ms. Neal. Again, these are primarily questions of whether or not that she acted ethically, and again, there's not really anything we can sit here and talk about in terms. And this is whether or not that she acted in a timely fashion with each of these appraisals, and rely on your knowledge and customs, or your knowledge of the industry to come up with a body of fact, and then potentially any disposition.
Ms. Neal, do you want to make a closing statement?
No, I don't think so. I don't have
Okay.
anything.
Do you have a proposed order?
I have several, actually, if each individual member wants to take a look, or would.
Yeah, if you would hand them to me, and I'll pass them out when we get to that point. Thank you. Okay, this matter will be submitted to the commission for deliberations based upon the sworn testimony of the two witnesses that we have heard from this morning. The state has alleged violation of state statutes and rules. The state has the burden of proof in this matter. The respondent does not have the burden of proving that she is innocent of the charges. The state's burden of proof is by a preponderance of the evidence, which means that the greater weight of the evidence is in favor of the state. Statements of counsel made during the course of the proceedings are not to be considered as evidence to satisfy the burden of proof. The Administrative Procedures Act requires that your order contain findings of fact, conclusions of law, a decision regarding the appropriate relief, if any, and policy reasons for your decision and determination. In making findings of fact, you must make your own evaluation of the testimony given by each of the witnesses. You must then give that testimony the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or commission rules or state statutes as alleged in the notice of charges, and if so, you must state those determinations in your conclusions of law. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your. If you decide that there has been a violation of a state statute or rule, you must then decide whether the relief requested by the state is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may grant the state's requested relief or decide that some other relief or none at all is more appropriate. Finally, a policy reason must accompany your determination to state why the decision you render in this situation is appropriate. Your policy reason tells the public and reviewing courts why the action you choose in this case is proper. The gravity of the violation and the respondent's attitude toward the action may be included in your policy statement to support your decision. All motions must be carried by a simple majority of the board. During your deliberations, additional questions of either counsel or the witnesses, it would not be appropriate unless you suspend a deliberation by majority vote and ask those. However, you can ask me questions if you need assistance in crafting your order. And I do generally request that the members of the commission engage in some initial discussions of the evidence and get a consensus of the ultimate decision that you would like to make regarding the conclusion law before I pass out the final order for your review. So with that, I will turn the matter over to the chairperson to preside over the deliberation.
Thank you, Your Honor. All right, ladies and gentlemen, you've heard what the judge has told us. Floor is open for discussion in this matter.
I'll speak, Mr. Chair.
That's a shock.
As far as I know, there are no laws stipulating due date when an appraisal is to be turned in. It is based on an agreement between the appraiser and their client. In this particular case, if the client had been concerned about slowness of work, they would have filed a complaint. They did not. Also, when it regards dismissing or stopping an appraisal in midstream, that's a business decision. That's not, in my opinion, something that we control over. It's an individual's business decision to make. I give an opinion at this point, or what are you?
Sure, go ahead.
My opinion is that I would vote to dismiss all charges against her.
Mansfield, you have an opinion?
I would agree with that with Mr. Atwood. I think everything that's presented here, again, is a business decision. I would do anything different if I felt threatened at all. So I don't think that's or can get complex, and we can get over our head. And it sounds like she commented and documented that with the lender. And again, I don't see any issues here. So I would agree with Mr. Atwood to dismiss.
Agree also.
Ms. Alexander, you want to add anything?
I would agree with what's previously been stated.
Doc?
I think Mr. Atwood spoke for me.
The only thing I would say is I've heard in so many discussions that the fortune is in the follow-up, and it does not look like Ms. Neal has very good follow-up skills. I suppose if it were me and I got a complaint filed, I'd call the commission to make sure they got my answer. The judge did tell us we could consider Ms. Neal's attitude, which I think has been very helpful and very congenial. So I'm gonna suggest a letter of warning and leave it at that. Further discussion? Do I turn it back to you, Your Honor? We need a vote on a decision.
You need to, well, you do need to vote on a decision. I'm just trying to think how we want to, there does need to be a crafting of some order. I don't know that the entire findings of fact and conclusions of law are necessary based upon, if somebody wants to explain on the record the reasons for, you did a fairly good job of explaining the rationale for the dismissal, but a vote on the record of that rationale and an ultimate conclusion would be necessary.
Mr. Atwood, would you like to put that in the form of a motion?
Yes, I'd like to make a motion we dismiss all complaints against Ms. Neal.
Have a motion to dismiss. Is there a second?
Second.
Have a motion and a second. Any further discussion?
Are the two situations the one that you suggested, Mr. Chairman, are they mutually exclusive?
No.
Be a letter?
No,
As well
they're
as a-
two different things, be two
Okay.
different things altogether, yeah.
All right.
Yeah.
Thank you.
Okay. Motion been made and second. Any further discussion to dismiss? Take a vote. All those in favor say aye.
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 All those opposed say no. No. Motion carries. Dismissed. Your Honor.
This contested case hearing is adjourned.
Okay, thank you very much. Thank you.
Thank you, and we will take 10 minutes break. Does that sound good before we start with the full commission
Sure.
meeting? Thank
Here.
you.
You want to turn that off?
Yes. Chairman Thomas, we're on the record.
I would like to call the October 2018 Appraisal Commission back to order. Our first order of business would be to adopt the agenda. However, I want to alter that just a moment before we adopt it, and just to welcome our two new members, even though Roxana has already done that. Miss Alexander and Mr. Mansfield, we appreciate you being here. Your voice is as important as some of us that have been on here for a year or two. So please speak up. We're glad to have you and glad to have your input. So look at the agenda that's on there. Do I have a motion to adopt the agenda?
So moved.
Have a motion to adopt the agenda. Do I have a second?
Second.
All those, any discussion? All those in favor say aye.
Aye.
Any opposed? The agenda is adopted. All right, second item of business is to review the 2018 July meeting. Our minutes. Have you all had a chance? Did everyone did not get information emailed to them?
All the board members did, the commission members, with the exception of our newest commission members that hadn't had a chance to go through orientation. Everyone else received an email with everything on it.
I did not.
You did not?
No.
That concerns me. I didn't see it bounce back, so. I apologize. I'll look and see what.
That's
I don't
why.
think it got lost. I could have hit a delete button and not
No
realized
worries.
it.
If you ever don't get an email from me, at least with it being always a Monday meeting, know that by Wednesday or Thursday of the previous week, I'll get you the agenda and everything, just in case you don't. But otherwise, it went out to everyone but our newest members.
All righty.
But you've got the minutes starting on page 3 of your iPads to be able to review.
Everyone had a chance to look at the minutes from July 2018.
I move we accept the minutes.
Second.
Motion been made and second to accept the 2018 July minutes. Any corrections or additions? All those in favor say aye.
Aye.
Any opposed? Motion carries. Before the education report, I guess this may be in order. Roxanne, would you like to introduce our legal staff that we don't know?
Oh, absolutely. Thank you. That was rude. Yes. So I believe at the last meeting, we had the pleasure of having Sarah Matthews for the last time, and she has moved on. She's not with Commerce and Insurance from the regulatory side. She's with insurance, and she'll come down and be happy to see all of you. I know she was here earlier, so we were sad to see her go. But we are thrilled to welcome Anna Matlock as our new counsel. You'll get a chance to ask her questions, I'm sure. Definitely tomorrow with rulemaking hearing, she will be very busy. She's been thrown at a 2-day meeting, which is not our normal procedure. And Anna's been very helpful with everything just leading up to the meeting. And then her supervisor, Denard, who I think you all have already met in previous conversations, but he will be happy to guide us through the legal report as well, and any questions you have. You've got 2 great people now here.
All right, thank you very much. Glad to have you. All right, our education report. And then when our education report is finished, before we take a vote or anything, I think Doc has a few comments. Doc?
There are 19 course applications. All the course applications are for continuing education. All others are, there's one course that is online. All the others are traditional classroom. There's one instructor for course 2223 who had a disciplinary action, but it was very, very minor. and I don't believe it would compromise course approval. There were 5 individual course approval applications. By a vote of 1-0, the Education Commission wants to recommend approval of these courses.
Jim, do you want to?
Yes, one of the proposed education courses is one that I personally submitted. Therefore, I would abstain from the vote on the record.
Heard Doc's recommendation on the education report. That's in the form of a motion. Do I hear a second?
Second.
Any further discussion? All those in favor of the education report say aye.
Aye.
Any opposed? Motion carries. The floor is yours, Doc.
Well, I just wanted to say that, when I come to these meetings and present the education report, pretty much we recommend that all the courses be accepted, and everyone is going along with that. And I just want to explain a little bit about the background on this. Why is it that all these courses are always recommended for approval? There's a lot that goes on before I ever get these courses. The people, the good staff of this office vet those reports. When I get them, the information in there, all the requirements have been met, and it's it doesn't mean that I don't go through them, but the point is that I don't have to figure out, is this really a course that meets all the requirements? Thanks to the hard work in the past of people like Dennis O'Brien, more recently Glenn Kopchik, of course, our executive director, Ms. Gamuccio, and her predecessor, Nicole Avers, have made my job very, not easy, but a lot simpler than would otherwise be the case. So when I come to this commission and present these, I want you to know that there's been a lot of work that's been done before I even get those reports. I go through them, or those applications, I go through them, but the point is that work has been very substantially, and that makes my part of the process a lot perhaps future.
Very good.
And I will pass that along to Glenn, because he,
Thank you very
thank
much.
goodness, has taken this piece on. Thank
Yes.
you.
All right, thank you, Doc. Now for our legal report. Anna, are you going to tell us how many cases we have to begin with?
For the legal report today?
Yeah.
We have, I believe, six cases before you today.
Okay.
And Mr. Mickens is going to present the legal report.
Okay, hang on just a second. You're going to present the legal report, and everybody, Doc, have you had a chance to look at them?
Very briefly.
Okay. The only reason I'm saying is we have 7, and I don't want to waste your time, but I certainly want to spend as much time on any of them as we need. But for those of us that have read them, case 1, 2, and 5 are recommended to dismiss. Does anyone have any discussion on those, or could I entertain a motion, get a motion to go ahead and dismiss those 3?
I recommend we dismiss those 3.
Second.
All right, motion been made and second to dismiss case 1, 2, and 5. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, motion carries. You're on the floor.
Could I take a second? I don't know if we do want to give a couple extra minutes to our newest members that probably haven't had a chance to go through, especially now that we've narrowed it down to those that are being dismissed. They may be able to skim through them a little bit
Okay.
faster.
Now, let me ask you this.
Yes.
I guess legal counsel, do you need to read those numbers into the record even though they've been dismissed?
Yes, I'd be happy
Okay.
to.
Just read the number, but know that they've been dismissed.
So for the record, the board has voted to dismiss case number 2018-04-0001, case number 2018-04-0431, and case number 2018-04-8231. Next on the agenda then for the legal report, this will be case number 3. That is case number 2018042791. I would be happy to summarize this case or let you all take some time to read it yourself, or we can go down to the recommendation, whatever you would like.
Okay, summary.
Okay. So this case involved an appraisal that was brought by the bank appraisal compliance manager. There's some specific concerns with the comparable sale. In this case, it was comparable sale number 3. There was a discrepancy about the square footage, and that let's see, the respondent had stated that he or she made some mistakes because they had the flu. The report was not particularly accurate, and that I think in this case we had that the respondent had hired a reviewer that stated that the report, if I can just quote from the legal report, the reviewers brought in by the respondent stated that the respondent used a comparable based on observation and the prior sale, and that the appraisal does not appear to be grossly misleading, and that any errors were corrected. This reviewer considered all the complainant's concerns and found that there were no USPAP violations. The state's reviewer had a different conclusion, and so they thought that there were a couple of USPAP violations, including standard rule, if I may quote from the report, standard rule 1-1B, standard rule 1-1C, standard rule 1-4A, and then standard rule 2-1A. And so one reviewer found that there were some violations, and the other reviewer found that there were not. If the recommendation by counsel was that, I think the recommendation by the attorney that produced the legal report thought that this would be best addressed by a letter of instruction, but of course we leave that in the discretion of the board.
Sure. Thank you. On number 3, Jim, are you a USPAP instructor?
Yes, sir.
Would you care to chime in first?
Yeah, I'm confused, first of all. Are the reports in the same order on this that they were sent to us?
They appear to be. You're not reading from the old minutes, are you?
The report for legal starts on page 30.
Hold on just a second, because I am still confused. Maybe I'm not looking at the right place.
Are you a USPAP instructor? Okay.
You're looking at old reports.
No wonder I couldn't figure out what I was doing. Thank
We're
you.
done with those. We're not going to relitigate those.
Thank you for straightening me
I
out.
understand that one.
Like one of my students.
Okay, you're going to have to give me a second to reread this.
Sure, no
because I was on
problem.
the wrong page.
No problem. Does anyone else have any comments about number 3? I just wanted a USPAP instructor's opinion before we did this. We'll wait for you, Jim.
Well, I read all this before, but while he was explaining that, I was looking at the wrong.
My question was going to be would it be your opinion that a letter of instruction is sufficient?
I recall when I read this earlier that I did not think that was sufficient, so I need to come up with what reasons I might have come up with earlier.
Sure.
Yes, first of all, there is a gross mistake in reporting the square footage. because of a improper inspection on the property, it looks like. The appraiser did not see the storage room, did not realize that a storage room was not GLA, so he counted it originally as GLA. Then there's a question about the camper being an improved property. So that, I recall that one. Apologize that I got behind on this.
It's all right.
Did you see a problem with the sales comparison?
I'm not sure if the sales comparison approach is all that reliable based on the fact that comparable number 3 is not a 1,768 square foot manufactured home, but is in fact a camper that the appraiser took photos of just the
on the lake
deck.
Yeah.
That that's at minimum misleading.
The reason why I ask is I'm wondering if we want to use as perhaps a way of redressing this, that he or she be required to take a sales comparison course.
Yes, there's a very important violation here. I just saw it again. The original inspection and the original appraisal, due to what he said was he had the flu, he did not drive by the comparable properties and take original photos. He used MLS photos. I'm assuming, we don't know this, but I'm assuming that he used the 1004 regular Fannie Mae appraisal report form in doing such, and I'm saying it's a he, I don't know, so it's generic. Inherent in the 1004 appraisal report form is that the appraiser, at a minimum, drives by all the comparables. He stated himself that he has not done that. That would be a violation of signing the certification, which is a violation of USPAP.
Recommendation. Anyone?
I'll go ahead. I'm caught up now.
Go ahead.
He's already had a letter of warning. He or she, they've already, I would say that the respondent needs to get the point, get the message, and so it is my motion that we impose a civil penalty of $2,000.
Motion's been made that we impose a civil penalty of $2,000 on case number 3. Do I hear a second? Second. Any further discussion?
Do you think there's any need for courses to be taken to help this person do better?
I think
so, which
minimum
ones?
Sales comparison, ethics, USPAP.
Well, they get USPAP on the renewal.
Right.
I would think more sales comparison in a report writing class, and I'd rather see the classes as opposed to civil penalty, because you may get some return. Hopefully they improve.
Okay. Any further discussion?
Well, do we want...
We'll have to vote this off, or
That's
vote
right.
this on.
Okay.
Okay, motion's been made and second that we impose a $2,000 penalty on number 3. There's no further discussion. All those in favor say aye.
Aye.
All those opposed say no. No. All right, the floor is reopened for discussion on recommendations for number 3.
I think you should get the fine and additional classes.
Is that a motion?
It's a motion.
Motion's been made. What's the additional, before we make the motion, what's the additional class?
The sales comparison and residential report writing.
All right. Motion's been made that we have a $2,000 fine, residential report writing, and sales comparison approach classes.
Second.
No, second, yeah. Okay, now we have a second. Any further discussion? Ready for the vote? All those in favor say aye.
Aye.
Any opposed?
No.
Okay. Motion carries. $2,000 in two classes.
I interrupt for just a second, just so that I'm sure I've got it. I've got the motion and the second, and we are talking about a sales comparison and then the residential report writing, no ethics with this vote, correct? No ethics. Okay. And the $2,000. Perfect.
$2,000.
And no set number of credits, so it'll be up to the litigating attorney to find the right number of course credits? Perfect. Thank you.
Now, just as a point of clarification, it's my understanding that with these educational classes, they do not get any credit for their renewals. Is that right?
They do not in this form. If we do it as
Okay.
part of the dismissal process, the agreed process
Right.
early on when they don't have any history and we bring those forth a little differently, then they can, but this one is different. That's correct.
Okay. Number 4, sir.
Number 4, that is complaint number 2018-047-031. This one is a little voluminous. I can try to summarize, or you can get down to the recommendation.
Yeah, Doc, you want to summarize it a little bit?
Yes, please.
Yeah, why don't you summarize them all?
Okay, so in this case, the complainants are the homeowners and the resident is the appraiser. The respondent was hired to complete an appraisal for a VA refinancing loan. The complainants complained that the respondent misrepresented and omitted pertinent facts in the report, that the appraiser was negligent, and that the respondent failed to follow USPAP standards and procedures. Specifically, the complainant has said that the respondent left out important facts about the home, including renovations and updates, and did not provide sufficient sales comps. More specifically, the complainants say that the respondent, 1, failed to exercise reasonable skill and care because in a previous appraisal, the prior year, the property was appraised at around $60,000 more. Respondent misrepresented the facts by stating that the entire front and one side of the complainant's home did not have a proper railing and did not include in their appraisal approximately 1,800 square feet of non-living area in the basement. Pardon me. In response, the respondent has said that the complainants are neither the client nor the intended user. The respondent says it had no information about what other appraisers had valued the property and what they recommended needed improvement. And then I guess the respondent also said that they had fixed any fixed any problems in their in their report, and then says it does not believe that the under porch storage area contributed much value to the house. The state's expert reviewer stated that the report is generally complete except for the following errors. The report said that there was a violation of, just to summarize, because there's many different USPAP violations listed, but as broad categories, they say that the report had a very minimal description of the neighborhood with a lack of geographical information. They said that the highest and best use analysis is not properly summarized. They said that the reconciliation exclusion of the different value approaches is not explained. They said that the extraordinary assumption in the addendum was not properly stated and disclosed. There was also an issue where tax record square footage was used without any explanation. And then that the market conditions addendum form was enclosed but was filled in with just zeros. So the recommendation was that this board authorize consent order for 14 hours of the highest and best use continuing education, which must be completed within 180 days of the consent order, and those hours should be above and beyond the minimum continuing education hours required for renewal.
Thank you. You've heard council's recommendation. Anyone wish to make a motion?
Can I ask you a question?
Yes, sir.
I agree with the recommendation of the highest and best use course. What about sales comparison and report writing? Oh, I ask the experts on our.
I would agree with report writing.
I would agree, too.
I just have a question. Is the highest and best use a 14-hour class?
14 hours with a 1-hour exam would make it 15 hours.
Yeah, okay. All right. Is that in form of a motion, Doc?
Yes.
All right, we have a motion repeat your motion, Doc, please.
Okay. To accept the recommendation of council with the addition of a sales comparison course.
Okay.
Second.
Motion been made and second to accept council's recommendation and add a sales comparison approach. Any further discussion?
Yes, he said report writing.
Oh.
Then your motion says sales comparison.
Okay, my apologies. I meant to say report writing, excuse me.
I was
Yes, well,
assuming
thank you
it
for,
was report
thank you for
writing.
listening to me.
Report writing and council's
I
recommendation.
did listen to myself. So
Yeah.
thank you.
Can we have the motion repeated?
Motion's been made to accept council's recommendation as well as adding a report writing class,
14 hours.
14 hours.
Total 28 hours,
Yeah.
correct?
Yes. Well, it's going to be more than that because a 14 is going to be a
Well,
15.
yeah.
Okay. Any further discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? New recommendation carries. Thank you. Number 5. No, number 5 we dismissed. Number 6.
So number 6 is on the legal report is a represent, and so this is case number 2017-076501. This case, to summarize, try to be as brief as possible. So in this case, the complainant stated that in requesting that the respondent do an appraisal, the complainant gave respondent a complete scope of work. Complainant expected respondent to comply with as discussed. Complainant states that the appraisal was incomplete, inaccurate, and unsuitable for use. Complainant states that the complainant was not able to view the appraisal until paying the fee, and that repeated attempts to contact the respondent were unsuccessful. Let's see. Respondent stated that the original appraisal was revised to correct the acreage. The respondent states that the owner was obtained from tax records and did not show the property was now owned by an estate. Respondent stated that other typographical errors and other changes were made were repaired in the revised appraisal as well. There were several reviewer conclusions. When this board looked at this before, there was a recommendation put forth of a $2,000 civil penalty for violations of standard rules 1-1B, 1-2E, and 1-2H, 1-4F, 2-1A, and 2-2-3. At the July board meeting, the commission voted to have the complaint reviewed by another expert and to be, so this was brought back before, so they were supposed to be represented at the July board meeting. The commission specifically requested that the new reviewer include in the report the scope of the engagement, a comparison of the scope to the engagement letter and the instructions from the client, if that scope work was communicated to the respondent, how the appraiser did or did not meet the scope, and how did the sewer relate to the highest and best use, did it have an impact on value, and if the appraisal was in compliance with TDOT. Okay, so then this case was brought back. The update number 1, based on the specific request that the commission had made, this case was represented in July, and so the scope of assignment that says the expert reviewer said that the USPAP has no term scope of assignment, but a definition of assignment in USPAP is an agreement between appraiser and client to provide a valuation service. Like I said, this is just to summarize even further. So once the board heard the new expert reviewer, the decision was for conditional dismissal requiring a 7-hour sales comparison course and a 7-hour cost course. So this is brought back again, sorry about that, but this is brought back again for the third time because this respondent went and got an attorney. That attorney got a third expert review from a licensee in another state. That reviewer looked at the original report as well as the proposed consent order, which included the 7-hour sales comparison course and the 7-hour cost course. The licensee's reviewer determined that while there was a potential violation of Standards Rule 2-2A8 as the sales comparison approach was analyzed but not summarized, none of the other facts and proposed violations were, in the reviewer's opinion, violations of USPAP requirements. The attorney therefore states that respondent will not agree to the terms of the consent order. So the recommendation from counsel was that, so just to get down to the resume, this is the third review and does offer many conflicts to the earlier reviews. While the respondent's reviewer was not a Tennessee licensee, the reviewer is licensed in a border state. The resume shows a history of experience. This would, if this were to go to a hearing, this would result in a conflict of experts where both sides would bring all their experts and you all would have to determine who you find more credible. As there was support of violation of Standards Rule 2-2A8, counsel recommendation would be a revised consent order with terms providing for a 7-hour class and sales comparison, and then we would not have the require them to do the cost course. And so that's sort of the recommendation after going hither, thither, and yon. That's where we've landed.
All right, you've heard council's recommendation on number 6. Any discussion?
Yes. I'm a little disappointed. We showed this respondent a lot of grace, giving them the conditional education, basically, and for the new members, for someone that doesn't have any disciplinary action against them, and the issues seem to be able to be resolved through coursework, we can recommend that they take certain education for their next cycle, and once that's completed, it's pretty much removed from their record and there's no history of any disciplinary action. And that's what we did in this case, and they've refused it. That's disappointing on one. Secondly, an out-of-state reviewer, although it's a border state, they're not licensed in the state of Tennessee, and even though if we do end up at a formal hearing, I would question their testimony based on not being licensed in the state of Tennessee. So I guess I come down to a question, because I'm this individual could have this in the books. They've gone out, hired an attorney. They apparently hired a review appraiser. They've already spent a ton of money, and this could have been over and done. So my question is, I'm ready to hit it a lot harder than what we did before, and if they want to go to hearing, we'll go to hearing. But we showed them quite a bit of grace. We even had it reviewed for a second time. Based on that second review, it was obvious that the report was confusing, and so if they don't want to take the normal education under their cycle, then we'll hit them harder.
I just want to make a comment, or just ask a question. Is there any member of the board who does T-dot work?
I don't think, and I went back and reviewed, I don't think this was necessarily an eminent domain. I think originally the situation was there was a strip acquisition either proposed or in the process from the state, and the first reviewer had concerns that wasn't addressed in the report, and they should have addressed it in the report. So I don't think, but we were, the biggest question with this report was, what was the scope of the report? And even the second reviewer sort of had questions what the scope of the report was.
All right. All right, we've heard council's recommendation and we've heard discussion. Does anyone wish to make a motion on number 6?
Mr. Chair,
Go ahead, Jim.
I'd like a comment. This was a confusing issue all the way around, and still is. We have a vote from the July meeting for a conditional dismissal, 7-hour sales comparison, 7-hour cost course. That is standing. That is what is there now. It is the respondent's opportunity to file for a hearing if they choose to. My recommendation or my motion is that we leave everything just as it is. They can do what they want to.
Just for a point of clarification, when you say leave everything as it is, the new decision says a 7-hour comparison, sales comparison, and a 7-hour cost approach.
That's on the books right now.
Right.
We leave it.
Right. Okay. Anybody have any further discussion?
I have a question.
Wait a minute. Got a motion on the floor.
Sorry.
I got a motion. Do I hear a second?
Second.
All right. I have a motion and a second. Now questions.
Okay. Do we have a copy of the review that was completed by the out-of-state appraiser?
Yes, we do. We don't have it with, I can try, we can try to go get that.
Is it acceptable, and this might be my ignorance, but is it acceptable for an out-of-state appraiser to do a report in the state of Tennessee?
Reviewer?
A review, without being licensed here?
That subject was, it does when they're working for a lender and they're under a lender exemption. This question, Sarah Matthews and I went back and forth several emails, and the wording on it is vague per se, but it sort of implies that it falls under the appraisal practice. They just don't have review mentioned. And that's something, and I would have to go back and look at our emails. And as recent as our last meeting in July, we were discussing this. Because a lot of our bordering states require appraisers to be licensed in their state to perform reviews.
Correct.
Therefore, we should follow the same suit. And the wording on the rules, and I could probably dig it up here on my tablet. The wording is just sort of vague, and Sarah was talking about trying to avoid going through rulemaking to change it to state that you had to be licensed in the state of Tennessee to do review.
I guess my concern specifically as it relates to this case is he obviously isn't licensed to do appraisal work here. This is an extremely complex assignment. I don't know how we could put a whole lot of faith in his review.
I agree.
And if it's a standard 3 review at that.
Anna, do you want to chime in?
I would just say it's up to your decision whether you want to give it more weight or not, because they're out of state. So I don't see that's up in the board's purview.
When it gets into a real litigation, I guess, in a litigation where you have two sides, if one of the appraisers is not licensed in the state of Tennessee, typically a judge will throw out their testimony.
It's possible, and it depends, if they're going to submit it for evidence or if it would just be probably. But that is also something that if this were to go into formal hearing, that you all would be able to weigh in your decision making to make a determination what you believe that particular expert would be.
Yeah. My question, why did they go out of state for a property in Tennessee?
I can't give you
I know that. Yeah, I know that. And this was over and done. All they had to do is accept it. And with regard to the motion on the floor, I would remove the conditional. We gave them one chance to accept it, and they chose not to accept it, and they want to take it the next step. And I would remove the condition.
I could on the conditional. I believe that when we send those out, they've got a short time span that they're good for. And so if they don't sign and agree, and it sounds like that was the case here, they didn't agree, then it just follows the normal course of it possibly being part of your disciplinary history and moving on.
Okay.
It's a quick window to resolve it.
Yeah.
All right, you heard the motion on the floor. We have a motion and a second. Mr. Garrison, do you wish to make an amendment to the motion?
Can I amend someone else's motion?
Or we can, if they accept, you can, yes.
I would remove the condition.
Okay, the motion was made by Mr. Atwood. You agree to that, Mr. Atwood?
I'll second.
Okay, and who seconded it?
Dr. McCure.
Dr. McCary, you agree? Okay. It's been agreed by the motioner and the seconder, if that's a term, that we remove the word conditional. The commission voted to issue a dismissal requiring a 7-hour sales comparison approach and a 7-hour cost approach. Any further discussion? Ready to vote? All those in favor say aye.
Aye.
All those opposed say no. The amended motion carries. Thank you. That completes legal.
Sir?
Thank you very much.
Mr. Chair?
Yes, sir.
On this particular complaint, there's several reviewers that the state hired. My concern is with the first one. I stated this when we first began reviewing this particular case. The first reviewer for this property, and I'm already on the record with this, in my opinion, was unqualified or gave inappropriate advice, again, in my opinion, showing that they were not qualified to be a reviewer on this. For example, there was a report, and then there was a revision to the same report. This reviewer indicated that that's two different appraisals. That is not two different appraisals. It is still one appraisal. He identified that the appraisal date should be changed because it's two appraisals. And if I understand this correctly, and all I have is what's sitting in front of me, when you revise an appraisal, you're still on the one appraisal. And so he does not need to change the effective date of the appraisal, although he does need to change the date of the report. But that's not what the reviewer says, and he goes on to even state that it's two different appraisals, of which it is not, which in my opinion disqualifies this reviewer from future work. That's just my recommendation, that you look whoever this review appraiser is. He does not know USPAP and should not be used again.
In the end of our, thank you, Mr. Atwood, at the end of our session here today, before we adjourn, I would like for you to bring that back up.
Okay.
All right. Thank you for the legal report. Yes, ma'am. You got something to say?
Chairman Thomas, I have one a clarification.
Okay.
The last vote and motion. So I believe you voted to remove the term conditional dismissal. So that would mean we would dismiss the complaint, meaning if they do the education. If you remove conditional, it would just be a dismissal. So I believe it should just be a consent order for the two education courses without the dismissal, because you cannot have just a dismissal.
Okay. That's why we have you.
Did that
That's not what
did that
was
make sense?
implied, yeah.
Okay, just want to make sure it would be
Yeah.
a consent order.
Do we need to take another vote or change anything, or just have legal do it?
If just to be safe, if we can have another vote for that, for the consent order authorizing the 2 courses.
Okay.
That's it.
Mr. Atwood, you heard legal's statement on what we need to do. Do you wish to make that motion?
I make a motion for a consent order to require the respondent to take a sales comparison and a cost approach.
Okay, Doc?
Second.
Okay. Any further discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? All right. Now, do we need to do anything with the first motion we made? Okay.
Thank you.
Thank you very much. Appreciate you keeping us straight. Director's report.
Thank you. Okay, you are on page 40 on your iPads. I'll give everyone a minute to get there. The first couple of items, or the first item is regarding the budget. We do not have closure for 2018 fiscal year just yet. So especially for our new members, I'm happy to answer any questions. This report is split into our revenue and then expenses below, and kind of a projected cost backs. So for the months of July and August, this is fiscal year, going in fiscal year 2019, we have at the bottom still a projected surplus. And quite a bit of cost backs are in there, but nothing for the closure of last year. So as soon as we have that, definitely for the December meeting, we expect to have it in the next month. I'm sorry that it's missed here. That is the final year end, I think, gives everyone that vision of what we're carrying forward on our reserves as well. But we're still in line kind of where we've been tracking. And we are getting information of more and more of the accuracy for cost backs, how legal's being charged back. So I hope to each month have a little bit more detail. But basically,
Does this piggyback on what I testified to in front of the Senate?
on the reduction of
Yeah.
fees, yes.
Okay.
But we're not feeling them yet. So
Okay.
you led me right to where I wanted to kind of go. So December 6th is our date for the changes in the rules. And the rules that are going into effect are a reduction of $25 from the renewals as well as our new fees to our applicants. So you have a $350 fee, which is the application fee itself, and that $350 is going down to $325. And then on top of that is $80, that is a transfer that goes straight to the appraiser subcommittee. So right now, you all are used to paying $430, that'll go down by $25, effective December 6th. So it'll be a little bit of time before we start seeing that reduction. But that'll go into effect pretty soon. Then I wanted to share some licensing numbers with everyone. On page 41 is some information that we shared at a meeting we had last week with some of our appraiser committee members, or commission members. These numbers are as of September, just to give everyone a little bit of a view of where we are. Certified general number in 2017, as you can see, that's the highest we've had. 69 new licensees under the certified general category, and then our certified residential, pretty consistent if we look across the board. For historic purposes, I was able to average 1991 to 2000 just to have, because statistics weren't kept the same way, just to have kind of an average. So we've been steady pretty much since 2011 with the numbers, and foresee that certified general will go up quite a bit before we hit December, but it probably won't reach what 2017 was. And then on the next page, I just did kind of a quick view for you of those licensees that we have, which is a total of 1,845. That is just in our 3 categories: certified residential, licensed, and certified general. It's not counting our trainees, obviously, and not counting our temporary permits that also take on a lot of volume in the state. But we've got a good number of our certified residentials, 918 of them, live in state with an in-state address, as opposed to out-of-state. Give you a quick view. I did run some numbers as well on our trainees. So in 2018, right now, we have a total of 218 registered trainees, 39 new ones added in this year of 2018. 2017, we added 58. That's the highest number of trainees so far, and I looked back to early 2000s, so that trend is probably going to increase now with the new path for them to come in. But we're at 39 so far this year. 36 in 2016, and that's where our increases kind of came in. 2016, 15, 14, where we were in the teens. And that's it for numbers as far as our budget report and information. Hopefully, we will have some full figures and be able to look at the 4-year projections, and by the time we meet again, definitely we'll have the rule in place, having reduced that fee.
Anything else?
No, I would like, if it's okay with the commission, we have an individual here ready to speak to the board, and so if you can, this will actually take a minute. I was going to have a skip, but we can go ahead and follow sort of the order of your iPads. The next order of business that we needed was to talk about the Aero Conference in Washington, D.C., and put that on the record. So I had reached out to all of our members to see if anyone was interested in going to this particular trip, and we did have a response and determined that Mr. Randy Thomas and myself would be traveling. We're heading out Thursday. It's a full meeting through the weekend, and then Monday's meetings are all day as well, including AMC information that will impact all the states doing changes on collection for the individuals on the panel and so forth. So we will be there Monday for sure. And I would need a motion from the commission to allow Mr. Thomas and myself to travel.
So moved.
Second.
Have a motion and second on the floor. Any discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? Motion carries. Roxana, do you want to introduce our guest?
Absolutely. Who seconded that motion? I apologize. Thank you, Jim. Okay. Thank you. So next, on order of business, you're on your iPads on page 46. Mr. Timothy Goodwin, if you'll give me a second, let me call him up. Mr. Goodwin. When you speak, if you can give me a minute. I will let everyone take a minute to read. His email is the letter that he presented, and this is a request for continuing to take the exam. So he has passed the allowed time to pass it, and he would like to present his case. On your iPads is also a medical form, and he has made several copies that we don't have enough for everyone, but I'll share in case you do want additional information.
Goodwin, thank you for taking the time to be here today. Do you want to make a statement and enlighten us a little bit?
I will. Thank you for allowing me to come, commissioners and chair. I originally reached out to Mr. Atwood. I took the fourth final exam on September 14th, I believe. During that time, I took a recently added dosage of medication that I was prescribed due to a medical condition. While taking the exam, I ended up, the medication, I had a reaction to it, dropped my blood pressure down to at the ER is at 96/48. Eventually fell asleep during the test. They couldn't wake me. My wife took me to an urgent care facility. Provided within there, I have the documentation from the primary care physician that reviewed the urgent care and the ER. September 19th, I believe, stating that I had a reaction to the medication, the new dosage that they prescribed me. That was on the fourth and final attempt, so I'm here before you guys to ask for another.
Thank you, sir. Questions from the board?
I have a legal question. He did reach out to me. I do know him personally. Do I need to recuse?
Yes.
I will recuse.
Anyone else? Any questions for Mr. Goodwin? You all had read the documentation, seen the documentation. Have you had time to look at the documentation?
Are you on any, special meds as a result of this?
Out of this, they actually lowered my dosage back to what it originally was.
So the problem was really the medication you were taking before,
Yes, sir. This was the first time I had taken the new dosage of it.
and you haven't had any repetition of the symptoms that you presented?
Nothing.
You going to pass the test?
Pass this test, yes.
All right.
Yes, I'm determined to pass it.
Any further to that? That's it. Any further discussion? Anybody have any questions for him? All right, the chair will entertain a motion on this matter.
Move to approve taking the exam.
All right, motion's been made. Do we hear a second?
Second.
Discussion?
Only question, do we need to set a time frame to which this is good for, or is it?
You definitely can. You can
Okay.
also say that he's got the one time to pass it, or would have to come before the board. And the time frame can be 2-3 months. It doesn't have to be, out a full year. It's at your discretion.
Any further discussion? Motion's been made and second. All those in favor say aye.
Aye.
Any opposed? Motion carries. You can take the test again.
Much.
Good luck.
Thank you all.
Pass it.
Roll
That's
Tide.
it.
Yes, sir.
Would you like your things back?
Yes, ma'am, please, thank you.
Need to discuss the, We need to discuss the National Registry, Roxana?
Yes.
Okay.
Yeah, and the only update that I wanted to give us on this is that I know the commission knows that we've not officially started adding the information to the registry. It's a two-part piece. We start adding all of our AMCs as well as the panel information. And so right now, our data's still not asking that question. So I think at this meeting in DC, we hope to speak to a lot of other states, find out what they're doing and how they're doing it. What I wanted to kind of run by the commissioners, my thoughts on how we could do it in Tennessee. We renew every 2 years, and the statute to collect the fee for the number of individuals on the panel is annually, as well as the audit and the fees. So, but I don't see that as a fact that they have to go hand in hand. I think our system would allow us the capability to do an annual audit of all of our AMCs, and right now we have 154, and send them paperwork so that my thought is the audit would run January 1st, 2019 through December 31st, 2019, and sometime early into January, beginning of February 2020, we would send a form saying, you are a licensed AMC. Based on the statute, you need to report the number of individuals on your panel, pay $25 per person, give them a time frame to report that so that we have the fees way in advance of the June 4th, 2020 date. So my thought is to have it on an annual, have the audit on an annual basis. Hopefully other states would be doing the same thing so that our AMCs don't have different calendars all over each state. We'll find out more in DC, but that our system could handle.
But this will not be ready for our January 14th meeting.
Not at all.
Okay.
Not at all. But I would like to sometime in January or February already send letters to the AMC companies letting them know we're thinking of doing this. So hopefully by maybe the April meeting, our next meeting. And
April 15th.
April 15th.
Great day.
And we voted on the dates. There we go, tax day. But I'll be happy to send out hand paper as well to everyone. They're already on our website. By April 15th, I would like to send out letters to the AMCs letting them know that we've decided to do the audit and collect the money and so forth based on a certain timeline.
Okay.
May I add some
Absolutely.
commentary? That'd be great.
I actually welcome your ideas. Before I head to, I was hoping that the meetings regarding this would be like Saturday or Sunday or early, so they're toward the end on Monday, but I'll be there regardless.
I don't really have any added ideas, but I'll let you know what we're already experiencing. There is no rhyme or reason to it. We just got one the other day that said from July 15th, 2017. Yeah, so up through July 14th, basically 2018 was their year. I'm not sure where we came up with that. And we needed to submit the number of appraisers. there's not going to be a good way to try and, I don't think, match up. I think your idea is probably the easiest for us to be able to compile, but I don't think there's going to be a real great general consensus. Many of the states do 1-year licensing, many of the states do 2-year licensing, but I don't see any of them changing their licensing. They are just adding an additional layer of yearly report the number, pay the fee. One of the ones that we recently got, I think Tennessee needs to send out some very specific information on what you're determining the panel is. We're getting information that is not consistent on what they're saying the panel of appraisers are.
How to determine the panel, or, okay.
Number of people on the panel.
Okay, okay.
Talking like how often they've done an appraisal for you or something along those.
They don't want to know how often. They want to know, are they on your panel?
Right.
What defines, are you on my
right.
panel?
As far as if you may have them on the list, but you haven't used
In order
them.
to them in
right,
3 years.
Right.
Correct.
Right.
So we need to determine what is the panel. Did they do work for you in the last 12 months? Is that what you're determining the panel is? Or I read one thing that you have access to them to do work for you. Well, if that's the case, then every appraiser in the state I have access to.
Sure.
So I need to know, what do you mean by that? Also, when we send out an assignment to an appraiser in an office and they don't complete the work order, but they have another appraiser in their office complete the assignment, is that one appraiser or is that 2 appraisers?
I guess for your last question, the thing that would jump to me is that second person you've sent it to on your panel, or are they just substituting as a one-time thing?
A lot of times they are not. Basically, the main principal in the office is.
Already. Mm-hmm.
And then they're divvying out the work and signing the report.
I don't know that each state has to come up with separate, different reasons of how to count the people on the panel and who should count. I think that's coming already from the federal registry, and my goal would be to send that piece to tie into whatever audit we do.
I've read it. It's confusing.
Yes. No, I'm.
All right. Anyone else? We're going to open the floor for just a minute before we close to each commissioner. Jim, you want to make a comment about your reviewer?
Yes, I've been, going back to complaint number 6, was it?
Yes.
Had several reviewers. The first one, we don't have names, so I don't know who we're talking about, but the first reviewer on complaint number 6, I would just recommend, I don't make a motion, I don't guess, it's just my recommendation to legal and to staff that they no longer use that reviewer.
Rex?
I think we need to be careful in doing that, especially as far as we've talked about setting up some review guidelines, maybe along with that, some qualification guidelines before we go recommending removing someone from the panel. We ought to have a little more basis for it.
All right. Doc, you got anything to say, to add?
No, sir.
Miss Alexander? Jason?
No, sir.
No, sir. One thing I want to add is 2 things. When we're asked to interview an individual, please get us up-to-date information. I was asked to interview one gentleman this time, and all 3 of the reports in August of 2018 were from 2015. I just couldn't understand what was how the reports were selected. So I'd like to have at least one appraisal from 18 if I'm interviewing him to have his license now. The other thing I would like to ask, and Doc and I have talked about it very generically, do we ever do anything as far as recertifying instructors? And the reason I ask this is I was in a real estate commission meeting the other day, and every 2 years their instructors have to, am I correct, 2 years, have to resubmit to be an instructor. And my rationale for this is I have been informed that we have some people teaching appraisal classes that probably are either past their time or not up to speed or not as good as they should be. And I was just kind of questioning, and I realized Doc made a good point, the marketplace will take care of a lot of that. But I just, I'm concerned. Rex is always talking about getting the education, forgetting the fine, but getting the education so that we improve them. If our instructors are not improved or good, we're really not doing a whole lot by giving them education. So I just had a concern about that.
I would add to that, what about getting the surveys from far as who's offering the class, as far as a response on the survey of the instructor, getting some feedback. And I think this is being done in other states, but they have to submit what kind of feedback from the students on the quality of the instructor. And that may be one way to do it as a recertify them, or we do both.
One caveat to that, and I don't really have an objection to that, but one caveat is it's like any other survey like that, you're going to hear from the extremes. The people who really like the instructor or really hated the instructor, those that are in between you're not going to hear much from. And you can just kind of get a biased impression of that.
Yeah, and I think on some of these you might be able to read between the lines. You'll get a few comments. Also, if you keep them over time frame, you're not only getting them for the one class, but you're getting them for multiple classes if they're teaching them. You're going to get some good feedback. And I know from professional organizations that approve their instructors, they want that feedback, and they keep instructors on their panel based on that feedback, and they have to keep a certain rating to be able to continue to teach.
I just wonder if we're going to get ourselves into a legal box there where an instructor will claim discrimination or some other reason why he or she is getting a low rating.
That's where you got to look at them and engage it and see if there's a pattern, but not necessarily go on a witch hunt or anything like that. Look at them and engage where they are. I think we need some accountability on that side. In other states, and maybe, and this is one thing, the advantage to the Aero conference is when you're there, you're with other states, some regulators, and you can say, hey, how are y'all handling this? And get some positive and negative feedback from other states on what they're doing and what they're not doing. That way it's sort of tested, but just a thought.
I have a comment.
Sure.
Too. I teach in multiple states, and each state, of course, has different ways of doing things. Some are very simple. Every 2 years you fill out a form, and basically it says, it asks me, am I qualified to teach this class? Well, of course I am. And so
An unbiased opinion.
I think all that is a moneymaker.
Sure.
Every 2 years and that's fine. If the commission wants to make some extra money, we could do that. One state, Alabama in particular, generally has auditors in the room. And not every class, but they're paid to be there, and they actually send me a report themselves. But that would take money. That would be cost to the commission or to the whatever. I could be wrong, but I'm pretty sure that for the Appraisal Institute, which I teach for, those ratings are confidential, and unless we have state power to make them give us that information, I don't know whether we have that power or not, they're not going to give it. And I'm glad. I mean, of course, I got good ratings, but anyway. But I would not mind, I personally would not mind volunteering. I get a copy of my ratings, and if you were to request that of me, I'd give it to you. So I don't know how we're going to get those ratings, actually.
I wasn't suggesting getting them. I was suggesting that they have a mechanism in place to rate their instructors, and I don't know what the right answer is, but I think we need some form of accountability.
I love the idea of we're there this week asking what other states are doing. Also on the course and educator provider things that we send you, Dr. McCara, if you can think of anything else that I guess but when the courses themselves renew or apply for any added biographical information on the instructors that maybe we're not getting. But again, it's still they're still going to give us everything that looks great, right? They're not going to say we had 5 bad complaints coming from.
Yeah, the only thing we get is if there has been disciplinary action. But of course, all the instructors are required to provide a bio and list their credentials, etc. And most of them are pretty clear and pretty convincing. You're always going to get probably 1 or 2 bad instructors along the way. That just happens. That's what my students think anyway, but that's another subject. Be that as it may, again, I'm not sure who would be responsible for deciding if this instructor passes the medal with regard to being allowed to present this course. Would it be legal? Would it be me or whoever the education commissioner is, or how that would happen?
Artie?
So we might be opening a whole
something to add as well.
Bunch of new things.
What if we use the surveys, if we did something like that, in conjunction with an auditor going in? So if you're looking at the surveys, hey, we've gotten 55% of these are negative. We need to send somebody in there to sit through this guy's class or this lady's class to determine what exactly is going on.
Could you send surveys for classes that have been taken and submitted for continuing education or qualifying education to those students?
Could the commissions? That's what I thought about, is if you had 50 people in the class, send out 10 people who have filled that out, just to hear what they have to say, knowing that it's going from them to us and not being handed to the instructor. Yeah. You got a question, Randy?
I think Dr. McCara brought up something really good.
Your name on the record.
Randy Button on the record. Is that how do you gauge instructors based on evaluations? And I think we've run into situations in the past where an instructor will be really good for one course, really know that material, have a lot of expertise, but then they're teaching another course, and you get a whole different opinion about the way it was presented. So I think that's one thing about the evaluations that will show you. It will give you a gauge to be able to look at this instructor over time, and are they teaching a new course or a new seminar that they may not be the best person to do that? Then that will give you some feedback. I know where I teach in other states, they ask the provider to send back their evaluations, so they're getting that every time, and there's a procedure and a process that they go through where the instructor doesn't touch the evaluations. They're mailed, the envelope is there, they mail those out directly, so it's going straight from the student to the board, which is a lot better, smoother process. The instructors don't get to see that, but then when it's compiled by the board, I get that back, that information saying, you got a 4 rating or a 5 rating or whatever. So those are things that are, I think just a quality control mechanism for the classes, because you can have great material which you're approving, but the person that's delivering that may be at a different level. So that's all I wanted to say on that.
Thank you.
There's some of you may be aware of this, I don't know, but there's a website called Rate My Instructor that students can, you know what I'm talking about, right? Where students can look up an instructor and see what the students say. It's like anything else online. You're not sure exactly who's putting it in. But I don't know if we had something similar that we could do for this, Rate My Instructor for real estate appraiser courses. And, that would provide information to would-be students for a particular instructor, and kind of get back to my point about let the market decide.
Sure.
I feel like the only problem with the market deciding is the lack of classes. We don't have an abundance of courses out there that you can take.
Anyone else?
I'm not sure we want to make any decisions today, but these are things we might want to think about.
Yes, sir, Mr.
Yeah,
Manager.
I'm not sure if this is the time for it, but just one point.
We're running out of time, so this is the time.
So one of my trainees has recently gone through the application process, and I've seen another member in the Middle Tennessee area who's gone through it, and they're having difficulties getting in the meeting. So both of these gentlemen have applied in July, and I guess because of lack of space or time or whatever, they weren't able to get into the October meeting. So you've got a trainee who you can sympathize with is probably on a limited salary. Once they reach that next bump or reach that license, they'll get an increase in income, and so then they're not going to get in until January at this point. So you're talking about 6 months from when they apply. And I know that we have a limited amount of time, and Mr. Garrison has. He actually took my trainee. He met with him outside of this, and so I would offer up that my time. I would be more than happy to meet with anybody. I just think if you apply within a certain period, we should do everything we can to.
I totally agree with you. One of the gentlemen he's going to meet with in the morning called me and said he turned his stuff in March and he heard nothing until August. The only thing he could tell me was his check had cleared.
Yeah.
So, but to piggyback what you said, we have had a number of commissioners meet outside of this meeting with trainees and then had a conference call to vote or a vote on it afterwards. So, yeah, we're working on that because we know that as this new license thing changes, we're going to have probably an influx. So, yeah, we're working on that.
And what we'll do tomorrow, because tomorrow we'll have a few more that are doing interviews, the new members will tag along and learn. So throughout the month, not just the meetings, our appraiser commission members are making themselves available, which is fantastic. It's on your personal time, so we greatly appreciate that. We are going to be sending you, and we've done this before, but for a long time we didn't have such a big need to really need to do this outside of meetings, but we only have 4 meetings a year, so it's a desperate need at this point. We will be reaching out, sending you hopefully updated reports. Anything that you're if you're not getting an updated report or whatever, and they're going to come directly from Heidi. So you should get everything from her ready to interview individuals, and we're going to try to keep them in your region so that you can get them done. And then once a commission member says via email to us in writing, I approve this, then we're moving forward and approving that individual to start working. On the record, we rectify and make sure that everyone is in agreement, but each commission member has that responsibility, and when you approve them, no one ever goes back and says, well, we want to look at it as well. So we can proceed and not wait on the meetings and get them out there working.
Thank you. Anyone else? I'll entertain. Yes, ma'am?
One more thing.
One more thing. This is a follow-up to the formal hearing this morning. I know there was discussion during the hearing of issuing a letter of warning, and I wanted to present before the commission. If you so desire, we can still issue a letter of warning outside of that hearing if you would like. So just wanted to bring that
All right. Thank you very much.
before you all.
But I'm going to respect the opinion of the board and let it sit. Thank you.
No problem.
I'll entertain a motion for adjournment.
So moved.
Second.
All those in favor, leave. Thank you very much. Yeah.
Your first meeting.
Nobody spit on me, they didn't throw tomatoes.